Hello, today with my colleague we are going to discuss the issue of fraud and promissory estoppel. So to start with, fraud is one type of defects of consent. And if within a contract it's proven that there has been fraud, this constitutes a ground for avoidance of a contract, but also a ground for damage claim. But what is fraud exactly? So according to the definition of the PICO, a party may avoid a contract which has been led to concluded by the other party fraudulent representation, whether by words or conduct or fraudulent non-disclosure of any information which is in accordance with good faith and fair dealing which should have been disclosed. So there is clearly this link with the good faith principle, which is a well-established principle in the civil law countries, and what it entails is that parties should not deceive each other, but there is also this aspect of playing fair and coming clean into a contract. We should remind that the main difference between mistake and fraud is that fraud has this additional requirement where the other party should have the intention to deceive. After having discussed the general notion of fraud, we are now going to discuss the promissory estoppel.
Promissory estoppel is the legal principle that prevents legal persons from not keeping their promises. This legal principle exists for the promisee to help them recover in case they relied on a non-formal promise from a promisor that caused them economic losses as a result of a promise not met. There are four main elements that need to be fulfilled for a claimant to use promissory estoppel in courts. Firstly, there needs to be a promisor. A promise has been made, and that promise is one that reasonable person will rely on it. Secondly, a promisee, who acted on the promise made despite the fact that there was no consideration. Thirdly, a detriment that the promise has suffered, an economic loss resulted from a promisor's failure to deliver on her promise. Lastly, the only possible compensation for the promisee is for the promise to be fulfilled. Promissory estoppel has various purposes. One of them is that it's a doctrine that protects the rights of a promisee against the promisor. Another one is that it seeks to enforce a contractual promise, either oral or written ones. In addition, it protects the promisor, as the promise shall be one that a reasonable person can rely on, and not all promises can be enforced under the doctrine. Lastly, the doctrine reassures that a party can trust the promise, and if the promisor is not willing to perform for one reason or another, the promisee will not come out injured.
Okay, then let's start with the first jurisdiction we're dealing with, that's Germany. Under German law, fraud is governed by paragraph 123, subsection 1 of the German Civil Code, which states that whoever has been induced to make a declaration of intent by fraud or unlawfully by threats may rescind the declaration. This means that if the fraudulent conduct can be proved, the declaration of intent is void and has no legal effect. Okay, let's have a look at the second jurisdiction we're dealing with, so the Netherlands Dutch law. According to Dutch law, the provision which is governing fraud is Article 344, subsection 3 of the Dutch Civil Code, which states that fraud occurs when someone induces another person to execute a certain juridical act by deliberately making an incorrect statement or concealing a fact that had to be disclosed or any other artifice. General endorsements, even if false, are not considered to be fraud under Dutch law. The consequence of this article is contained in the first subsection of the same article, which states that a legal act is voidable where it has been brought by fraud. In the Netherlands, the mistaken party, in order to claim damages, needs to prove the fraudulent conduct of the other party. But it's not always as easy as it seems to prove the fraudulent conduct of the other party. Furthermore, it can be said that silence in both Germany and the Netherlands can be considered as fraud. So if some fact that had to be disclosed is concealed, this may amount to fraud as well.
In France, fraud is defined under Article 1137cc as an act of a party in obtaining the consent of the other by shaming or lies. The intentional concealment of information by one party, where he or she knows it is decisive for the other party, is also considered fraud. For the consequences of fraud, we need to look at Article 1130 and 1131cc, which is the nullity of contract. In all these three jurisdictions, we can see that there has to be a causal link between the concealment of information and entry into contract. The importance of fraud and promissory estoppel lies in the fact that both legal tools protect the rights of a victim party. They hold parties who are in any way wrong towards the other party accountable for their actions. They also help prevent injustice in the area of contract law when general contract law rules would cause unfair results to one of the parties.